All right, so we're back in this classroom, and it's filled to capacity. And anyone who missed this class, the angels will weep for you. I'm passing out the graduate schedule, which I do not have online. I hope I have enough copies here for everyone. Oh, here it is. And now, as it happens, we can talk a little bit about some of the courses which are available to you next semester. But first, if you flip it over, you'll see there's a graduate summer schedule here. And we're offering Green Power, which is not a course that we've offered recently. Jeff Dennenberg will be teaching it. And Green Power is one of those courses that I think is very topical, and it deals with all the different alternative energy sources which you can have. The other thing you might like to take, which I think is very interesting, our very own Professor Munden, who has come to us from Yale after growing nanowires for his PhD thesis, is going to teach us about nanoelectronics, which I think is a very interesting thing. You could, in theory, take both courses with Green Power on a Wednesday evening and nanoelectronics on a Tuesday evening. You basically can pick up an easy 6 credit hours in an interesting area. Moreover, after this course, if you're able to get B or better, you can proceed and do a thesis if you can find a thesis advisor. Now, I am available and I am listed as a thesis advisor, but I can't be an advisor for everyone. So if you want to do something that's outside of my area, we'll find you a faculty member, or you will have to forego the thesis. In other words, it has to be an area where someone feels competent to advise you. So that gives you, let's see now, 9 credit hours available in the ECE program. As far as electives are concerned, anything at the graduate level is available to you. It does not have to be in the School of Engineering. So if you find a graduate level course in the School of Business or in the math department, or even off campus, up to 6 credit hours worth of classes can be taken off campus. So if you said to me, well, Nobel Prize winning Professor Schiller will be teaching about economics over at Yale, you could take a course at Yale and transfer it over. And that would be a very fine thing. So just make sure you get permission to do those sorts of things prior to doing them, and then you'll be all set. Hello. Here, have a schedule. You missed the little lecture on what it is you can take. So then, and now after, here comes more people. Oh, so you missed the lecture on, you don't want to schedule? Yeah. All for you. So now I thought what I would do, presumably you all have submitted your midterm. It was due today, right? Yes. And any troubles or questions about the midterm? No? Okay. Hi. Oh, you came in late. You missed the lecture on what it is you can take this summer and next semester. I was trying to combine a little advising with the class. But the bottom line is there are 9 credit hours available to you this summer. Nano electronics being taught by Professor Munden. A Green Power course being taught by Professor Dennenberg. And a thesis which is available to you if you get B or better in this course, and if you can find a thesis advisor who is willing to take you on as a student. So if it's something that I know anything about, I might be willing, but if I really know nothing about it, we have to find someone else. So I have to, sort of agree to take you on as a student first. And I can, guarantee you most people don't want to do a thesis. And it's an option. any graduate level course being taught at this university is fair game for you to take as an elective. Any graduate level course that you have permission to take off campus is fair game for you to take as an elective. Up to 6 credit hours can be transferred in, provided you get B or better in the course. But you got to get permission in advance. So say, oh, here's a course at Yale I want to take. Fine. Good elective. B or better. And then you can do up to 6 credit hours. So you can take courses, perhaps if you are returning to wherever it is you live. If it's far away, maybe they have some courses you'd like to take wherever that is. Maybe we can transfer them if they're graduate level and B or better. So that's an opportunity for you to take courses this summer, and also we have some nice courses being offered in the fall. Are people around here during the summer? Some people. That's good. I wanted to talk a little bit more about patent protection. And I also wanted to talk a little bit more about how you would proceed to do a thesis and keep a proper notebook. And by a proper notebook, what I mean is a notebook that would be accepted by a court of law if you wanted to prove priority of your ideas in the case of a patent litigation. So patent litigation is an interesting area of law. People who will infringe on your patent may do so without knowingly infringing. People who infringe and knowingly infringe may be liable for triple damages plus court costs and legal fees. People who are having to prove that they were first to invent and have invented will be required to document that. And in order to document it, you will need what's known as a laboratory notebook. And so there are different ways in which you can keep a laboratory notebook. Many people like to keep their notes electronic. I advise strongly against it because the court system has not caught up to it and does not recognize the inviolability of the electronic notes. So when we talk about a patent protection, we also have to talk about who gets a patent. And can anyone answer? Who can get a patent? Not anybody. Not anybody.
Well, technically anybody, but you have to be an inventor.
Inventor. You have to be an inventor. Only inventors can get a patent. And that is a legal requirement. Inventorship is something that is defined by the code, and it says here, this is a subsection of what's called Part 35 of the United States Code. Only an inventor can be awarded a patent. And if you have two people filing, then they must file jointly. So if you have co-inventors, so then the next question is, how do you know if this person is a co-inventor? This is a big problem, right? Because sometimes you work in a company and there's like a technician, and he's just a technician, right? Maybe the technician happens to be, I'll call him a skilled machinist. That's quite possible, right? If you have a person who's very high-end, he could be the person who says, but the technician is the person who does, right? And that skilled machinist brings their skill and know-how to the field. They can solve important problems. The courts can rule that they are co-inventors. This is very important because you think, well, it was my idea. I told him what to do. But they figured out the intricacies of making it work. They figured out how to embody it so that a layperson in the field could make it function properly and not get stuck or whatever it is that it's doing. For example, I'll give you a good example. I had this idea that we should have a laser printer which takes paper and moves it through a paper path and imprints charge and makes toner happen on top of the charge, and the toner sticks, and then it goes through an oven and it bakes the toner on, and then it comes out and it looks very nice. Okay, is that an invention? Maybe. I had a concept. I had an idea. But can I sell that idea? Maybe not. I have to find a way to build a prototype that embodies that idea. There's a lot of details in making all that work. How am I going to make this laser printer pick up the paper so that it doesn't jam? How am I going to, get the toner right at the right size? How will I make the oven the correct temperature? All of these little details, if I'm not able to prototype something and make it work properly, I must rely on others who will help me build the computer controller and the interface and the raster image processor and all of the junk that goes on with the chemistry of the toner. And if I have to rely on others to do that, it's quite likely that they will become co-inventors, because there are other areas where development has to occur before that laser printer will become a practical commercial device. And this is almost always the case. You work on a team, especially for a big project like a laser printer. That's a big project because there are so many different areas, right? You may not know anything about the mechanics of handling paper, whereas you might know a lot about something like the chemistry for melting toner. But maybe you know nothing about the computers for the image processing and the networking. So there's all these different problems, sub-problems. So then you have to come in front of the patent office and sign that you are the inventor when you file a patent. I'm the only inventor. I worked all by myself. I did my own thing. I'm the inventor. Award me the patent. And you take the oath. And then once you do this, you say, oh, and I'm the first inventor. If you're the first to file and you're the first inventor, the patent is yours, assuming the patent office allows it. And now the patent office will do a search. The patent examiner will do a search, and the patent examiner will look through the literature, not just the old patents. They'll do a real literature search like you guys have been doing, and they'll say, oh, they'll look at the IEEE journals. They have all the access online. They have access to everything online. And then they do that search. They'll say, hey, this is a pre-existing device. You say, oh, I'm going to do GSM home security system. They'll say, wait, that's already being offered for sale. This is not new. So, oh, but mine is different because mine is solar powered. No, that's offered for sale too, right? Oh, well, mine is different because mine is something else. Who knows? So you have to be very careful about what it is you claim. Someone else is there. So you have the concept, right? This idea, conception, the today I am brilliant idea, and you came up with this mental idea of the invention. Probably some of you have had this already because you have these theses and these midterms that have been written. Can someone give me an example of some idea that they've had they think might be patentable? It doesn't have to be, but it's possible. Anyone here have a patentable idea? Maybe?
I just saw an article in the Wall Street Journal about harvesting energy from the ocean floor.
I've got a great one. We can power a whole house from the breeze that we get from the opening of the refrigerator door. Right? Oh, that's a good one. If you can make it work, right? That's like the perpetual motion machine. Because whenever I open it, it's very cold. So they have energy from the ocean?
Yeah.
Oh, all right.
3 different methods, like underwater turbines, like a windmill.
Oh.
Another one is like a wall that the water flows through, spins a turbine or something probably.
Mm-hmm.
And the other one is like some sort of a pumping system that has to do with hot and cold water, like being forced through a turbine, sort of.
Well, I think if you take a light bulb and you put it in a jar and don't show them that the light bulb is plugged in, you can just say it's cold fusion, and everybody will say, "Ooh, infinite energy."
Why would we charge you?
So I have this notion that there are these things that you sit around and have these ideas about, right? Sometimes that's why I think they pay professors the big bucks. They sit around and have the big thoughts. We sit around and we think about big ideas. And so one might say that if a person with ordinary skill can be taught how to reduce your idea to practice, then you can be allowed the patent. But you say, but gee, if I do that, then everyone will copy me. That's the danger. If you do not give sufficient information for people to duplicate your idea, then they may disallow the patent. So if you just say, oh, I've got this idea, and it's called a laser printer, and the paper goes in here, and toner goes on that, and then it comes out, and it looks nice. That doesn't allow you to reduce to practice. It's not sufficient information. No one can duplicate your idea in this way. So the most elementary of laboratory behavior is to repeat the experiment. Someone with ordinary skill in the field. Ordinary skill in the field can mean, yes, they're an engineer too. So if you had this idea about the laser printer, you would have to at least give sufficient detail to show how your prototype works. Now, it used to be that you must supply a working prototype before you could get the patent. Imagine what that must have been like. Oh, I've invented a new loom. Well, what are you going to do? Take the whole loom and bring it to the patent office? In fact, yes, that's what they did. You can say, well, how do I do a giant, humongous loom? You make a miniature model. And so the patent office in the 1800s collected many, many models of different things, and you can go and you can find these original models. And some of them are for sale. Original models of looms, little looms, not the ones that you might use for, a big textile factory. And the patent office had these because they were submitted. It was required in order to get a patent. You had to have a real physical model. This is before computers, before software, all this other stuff. Now, what I have seen is people are supplying software patents, but the actual code comes on a CD-ROM and it doesn't appear in the patent. So if you want that code, you actually have to physically go to the patent office down in Washington in order to be able to duplicate the CD-ROM. It's very clever because in this way they can create what we call in the business the secret sauce that prevents you from duplicating whatever it is that the company has created. So it allows you to mix things which are patented and things which are proprietary. And so the proprietary part might be the code. And that code is usually subject to a copyright. The algorithm can be patented, but the code can be copyrighted. Now, if somebody gives you some code and you say, I would like to use your code, but it's copyrighted, how do you get around the copyright? Yeah, change it. How do you change it? What would be a good way to change it?
All you have to do is, if your code has a certain loop or something, put in your own loop, anything. I mean, you can just really...
You could effectively take a C program and you could rewrite it in Java. That gets around the copyright. If you take a program, as you say, and you rewrite it in a way that makes it look materially different, it gets around the copyright. The question, how much do you have to rewrite it? That's another matter. It's not clear. So, how do you know if something is obvious? Right? If somebody says that your patent is obvious and therefore cannot be granted, that's typical. And when they say that, it means that the patent examiner has initiated what is called an office action. And you must respond to the office action within a certain period of time. sometimes 30 or 60 days. And then if you do not respond, then you can lose the patent. So they force you to respond. I've done many back and forths with the patent office doing these office actions, one after another. Eventually they wore me down. And I just said, I give up. And I lost the patent. Because I was doing it myself, and I didn't feel like paying a lawyer. How do you know if you should get a patent?
It's your own personal judgment call.
Well, there's two criteria. Okay, the first is if it has to be in your own mind patentable. So if it's not patentable, don't bother. And the second is, anyone take a guess?
Something that can be reverse engineered.
How about making it a business decision? Patents are expensive. It takes time. It takes effort. Lawyers charge in this state $300 an hour. Now, if you're going to pay somebody $300 an hour and then $10,000 worth of patent fees over the life of the patent, it had better give you a return on your investment. The decision to get a patent or not, after you decide that it's patentable, is a business decision. Getting a patent is a business decision that says, I have a way to get a return on my investment. If you said, I can make $7,000 on my little Arduino Kickstarter project, right? Will you get a patent? Oh, no. Not no, but heck no. Why? Because patents cost $10,000. And this little doodad that you're selling sold for $7,000 and that's it. So there's no way that you can justify financially getting the patent unless it makes you feel good about yourself to have a patent. There's just no, it's pointless. Don't even bother. Right? So when I did a provisional patent application based on this Kickstarter project, I didn't know how much it was going to be worth. Now I do. So I abandoned the patent. Now, if you file for yourself, in Latin they say that's a pro se filing. That's the legal term. Pro se means for yourself. You become what's known as a small entity. You're just you. When you're just you filing for yourself, you can pay $80 and do a provisional patent application and lock the patent down for a year. And you get a whole year in which to decide whether or not your Kickstarter project will take off or whether your patent is worth getting. If you, after a year, decide it's not, then you've lost $80 and some time to file the provisional. Other than that, it's perfectly acceptable to abandon it. 75% of the patents are abandoned after a regular patent application. That is, after they've been accepted by the patent office, licensing fees came up, people still abandon them because they don't want to pay the extra licensing fees. What that means is 75% of the patents that were granted were not good business investments. People thought they might be, but they got abandoned anyway. So it's very hard to value a patent. Very difficult. Valuation of a patent is something even the professionals get wrong. Kodak used to make film in this country for over 100 years. Big company, everybody heard of them. Has everybody here heard of Kodak? Yeah. And it's an international company. Well, it was going bankrupt. In this country, it's in Rochester, near Niagara Falls. We'll call it Western New York. And the company, as it was going bankrupt, had this large patent portfolio, which they had independent consultants, professionals, come in and value at $2 billion. And they said, we're going to sell these patents and we're going to save the company. And nobody wanted those patents, and they were able to get no more than $100 million. They were off by many orders of magnitude because valuing patents is very difficult. So when you see somebody like Google buying Motorola and doing it because they want the patents and they pay a couple $1 billion for Motorola, turns out That wasn't a very good investment for them because they turned it around and sold Motorola at a big loss. And I think they sold it to Nokia or somebody. So there was really not a whole lot left, and valuing patents is tough. They way overpaid. So then comes the big question, what's conception? Did the Wright brothers invent the airplane? Did they? Gustav Whitehead is honored as the first in flight, and Gustav Whitehead is a native of Connecticut. If you, huh?
You say his invention was also better than the Wright brothers?
And his invention was actually, they have a model of the Gustav Whitehead plane in the Connecticut Aviation Museum over in Stratford. If you ever have occasion to go to an interesting museum, that's one of them. The fellow who runs that museum comes and visits here regularly, and he was here last night at the IACT meeting. We had over 50 people at that Inventors Association of Connecticut meeting last night, and I was on the panel, and they were all talking about the crowdfunding. You all could have come if you'd wanted to. One fellow raised $85,000. That's good money. That's good money. I don't know if you guys had seen that. Did I show you the IACT meeting from yesterday? Inventus.org. Past presentations. Next presentation. This is, so it was, yeah, that's it. Michael Carponzo, he raised $85,000 in his Kickstarter project. Cliff Thier, he raised, geez, they don't say, but I think he raised over $11,000 for his little cup holder. $11,000 worth of cup holders. Jennifer, she raised $28,000 for her little venture, which was bringing computer education to women in the Midwest. Bella Minds means, it's Italian, it means beautiful minds. Bella means pretty. And Doug Lyon, that's me with his little widget. I was low man on the total poll on this one. I talked very little. And then Mark, he's the fellow who inspired me. He's a patent agent. $300 an hour for this guy. I know, because I asked. So it's a it was an interesting panel, and that was yesterday. I don't know if, did you guys know about this? Yeah, you got an email. Yeah. So you knew. I frankly don't like to do these things because it's after my bedtime. 7 o'clock, it's so late. But I go anyway because I feel obligated, especially because my name is on it. If I don't show up, I think there must be something wrong. It's not good to be out late on a school night. Makes me tired. I've been drinking tea all day. Doesn't help. So, do you think the Wright brothers should have gotten the patent? If Gustav Whitehead had the airplane first? No. There must have been something else that they had a claim to. Now, one of the things that the Wright brothers did in order to cause the airplane to steer and be controllable is they did a thing called wing warping, where they bent the wings. Now, here in the New Age, we have things called rudders and aeroplanes and elevators, and they allow us to have roll, pitch, and yaw for the airplane. But back then, they didn't have any of those ideas. They actually warped the wings. They bent them in order to have control over the airplane and steer it. And so they could have patented that because that was an interesting idea. Gustav Whitehead didn't use that technology. If you look at Gustav Whitehead's airplane, it looks like a boat. Literally. In fact, he used some of the same manufacturing techniques that boat people used to make his cabin. So when you want to prove that you have conceived of a notion, you do it by documenting it. And you document it using what's called a lab notebook. Now, a lab notebook requires that you write in it regularly. It requires that you date everything that you do. And it requires that you have something that is written at the same time as the conception. The time of conception is documented. You know, you do something, you say, oh, this is amazing, and you write, Eureka! And then you want to document the fact that you've done this, so you probably want it witnessed. And so there's a proper way to witness these things. First of all, when you have the pages in your notebook, you must make it so that if a page is torn out, it's obvious. It's obviously been torn out. So what I like to use is I use a book where it's been sewn. Although some people use spiral notebooks where you can tear pages out, I number every page in my spiral notebook. And then I leave space for the table of contents. And then what you do is you write read and understood, and then somebody signs it and dates it. And you have to show it to someone for a witness. Someone, perhaps a lab partner or someone you know. And then that shows that you have a moment of conception. It's been documented. That's acceptable by the court. So this is the kind of documentation that really does have to be written. And you can see why it can't just be something you put in your iPad, because that could be doctored too easily. This has to be something that, provides evidence. So lined paper, I use that. Number all the pages. Sometimes at boring meetings, you can see me turning through the pages, numbering them by hand. Although you can buy pre-numbered notebooks. I have a bunch of those as well, and they have sewn pages. The first 10 pages are reserved so that you can have a table of contents, so that you can find things. I write table of contents on the first 10 pages, so I know that it's reserved for the table of contents, and I number every page so that when something is put in with a header, that goes in my table of contents. It's totally anal compulsive, and people who see it think I'm sick. Too bad for them, because they will not get patents. So an inventor's notebook is a very precious thing. You keep it forever. I keep my notebooks. I have them from the early 80s when I started keeping notebooks. And I have always kept notebooks. They're like a diary, but a technical diary. Every time you write something down, you date. So it may be trivial, whatever. Always put the date in. Always have somebody sign read and understood. And it's legal. The courts will recognize it. This is the key. The documentation is important because it establishes your priority on your idea. It establishes the priority of your invention. I put a title and date on every notebook after the notebook is done. So because I have a binder, I write the date with permanent marker on the binder, and then I file it next to the other notebooks. So I keep all my notebooks together. And I keep them forever, and I never tear out a page. And if somebody tears out a page out of one of my notebooks, I freak. Like, what are you doing? You don't tear out pages from this kind of notebook. It's a special notebook. If you work for a big lab, I worked for AT&T Bell Labs, they have their own special notebooks, and everything you put in those notebooks belongs to them, because you're working for them, and so they have assignment of all the patents, but they're not the inventor. So you can be the inventor, but you may not get the benefit of the patent. you might get some royalty from the company if they're nice, but all the assignment goes to the company in general. As an employee of Fairfield University, if I use Fairfield University laboratories, and then I proceed to file through Fairfield University for a patent, I can be the inventor, but I still will have to leave the assignment to Fairfield University. They take it all. And then they give back royalties to me. Same thing if you work for me as a research assistant in my laboratory, then what happens is you and I both assign the whole thing over to Fairfield University, and then we get royalties back. So what that means could be 5%, could be even a little less, depending on what the arrangement is. And you could still be an inventor, but you're not necessarily getting the benefit. I know some people who have 40 patents, sometimes more, and they don't get any assignment because they're working for some company. This is what happens if you work for a company like ASML. You could come up with lots of inventions, one after the other, all patented, and yet you get no financial benefit at all, other than perhaps... I beg your pardon? Yeah, I got a bonus. It was like $500 or something. So, thanks a lot, buddy, you know. But they take everything. So then comes this big question about how do I know when it's a joint invention? I've done joint patents before with co-inventors. I wasn't always happy with the way things turned out, but once you represent yourself as being a joint inventor, it's very difficult to have your name removed. If you associate with your name with specific claims in the patent and a claim is disallowed, that could have your name removed. But then you have to prove that that claim is associated with you. So you could say, well, Doug Lyon, he did the thing about handling the paper. You could say, well, we're not going to allow the paper handling claim anymore for the laser printer. So now we don't need Doug Lyon as a co-inventor. And as they remove the claim, they could also remove the co-inventor. So that's kind of an interesting idea, right? Because now invention is linked to claims in the patent, and if the claims are disallowed, the inventor could be disallowed. So, can I work at a distance? And the answer is sure. Right? So I could pick up the phone and I could say, hey, what about if we try this? And if it works out and it becomes part of the invention, I become a co-inventor. I could have an idea. What if I don't do very much work on it? I just had an idea. Still an inventor. I don't have to contribute to every claim. So, what would be a good example of somebody contributing a basic idea? Can you think of any inventions? Yeah. You guys have you know the invention of television? People thought blowing the glass tube, the television tube, was impossible. No one knew how to do it until one fella who worked for Farnsworth decided he would take what's called an Erlenmeyer flask, which has a flat bottom, and modify it, and then put in the elements for the tube, and then seal it after sucking out the air. And coating the bottom with phosphor enabled them to build the first television tube. Similarly for the camera and the camera tube. So once these things were devised, right, the moment of conception, they became inventors as well. It was Philo Farnsworth who invented the television, but it's not a name that's well known in history because David Sarnoff and RCA basically stole the invention. And this is an interesting artifact because what they did, they had a laboratory in San Francisco, and afterwards they would go out to the bars and go out drinking. And what David Sarnoff did, president of RCA, is he sent beautiful secretaries into the bars, and they would play up to these laboratory geeks, and they'd say, "Oh, how interesting! Tell us all about what you're doing. Oh, we're inventing television, blah blah blah." And they'd say, "Oh, wow, how does that work?" And they go into the detail because you know how engineers like to blab, and so they just pretended to be interested, and then they took that information and they brought it back to Sarnoff's lab and basically stole the idea from Philo Farnsworth on television. Is how RCA operated. But which, by the way, is not illegal. Interesting though it may be unethical or perhaps immoral, it's not illegal to go to the bars and pretend to be interested and have people blab about their inventions. So what they did was after they outpaced Philo Farnsworth in the invention, they filed their own patents. And the court said, well, RCA must have invented it first because they're a big company. And the big company won the patent litigation. And eventually it was overturned in Farnsworth's favor, but not until he passed away. And so it was only his wife who was able to yield some of the benefits of that patent. So when do we say it's not joint inventorship? If I say, well, I think maybe you should store your tea in a cup. You say, well, that's obvious. But then the question is, how do I know it's obvious? If I didn't think of it first, it wasn't obvious. Right? So what if I suggest some idea, and what does merely suggest mean? Does that mean I have to follow through with the idea? This is the part where I get really confused.
So in the case of your machinist,
Yeah.
you're the inventor and you give instructions to the machinist, and he just finds the way to engineer this product. In most cases, that would be like a mere suggestion, because it wouldn't be a claimable difference to your invention. In most cases, he's just producing your invention essentially. So even though he says like, well, this screw shouldn't go here, it should really go here, that's really like a mere suggestion as opposed to a claimable element of your invention.
So is it if I give you detailed instructions and you follow them, I can see where you might not be considered an inventor. But if you're a machinist skilled in the field and you figure out how to do something that I really didn't think about very carefully, like for example, let's say I have...
It depends on the hypothetical situation.
Yeah.
There are times when they could, because the method could also be patented. The method of producing your invention could also be patented. So in a hypothetical situation, the machinist could have discovered the method, in which case you'd be able to claim, the two of you as joint inventors would be able to claim the method and the product in your patent. But there's other times when he's not really finding the method, he just made a little change to the way that you already told him the method of producing it.
Well, suppose I said, well, I really want this paper to roll through the paper path, but I don't want people to be able to pull it out. See, so then the machinist says, oh, I know how to do that. I'll take a worm gear and I'll put it against this other gear, and that'll keep you from pulling on the paper, and it'll still be able to drive the roller. And you could say, oh, wow, I didn't think of that. So now is the machinist an inventor?
If you claim that additional element that he just
then
added, then
yeah.
yeah, he would be a joint.
So now I got worm gear that prevents the roller from being from allowing paper to be extracted manually.
Yeah.
I put that claim in there. He's a co-inventor. The patent examiner says that's obvious and disallows the claim. So now he's no longer an inventor.
Yeah.
So the inventor has now become linked to the claim, and if the claim is disallowed, he becomes a non-inventor. So then the question is, well, we didn't think of it. Why is it obvious? And so then the question is, yeah, it's a standard way of doing things, or it's already been claimed in some other patent. So if it's been published as a technology that's already well understood, one can make the claim that publication is a positive barrier to patentability, in which case it is not patentable, and the claim is disallowed, and then the individual is no longer an inventor and quits in frustration. I mean, those machinists are hard to come by.
I think one of the Wright brothers actually passed away before the patent actually issued, and they complained that it was from the stress of like back and forth litigation and the years of like dealing with it.
I'll tell you a story. Mauchly and Eckhart were working for the Ballistic Research Laboratory in University of Pennsylvania at the Moore Electrical Engineering School. And they were creating the first general-purpose digital electronic computer called ENIAC. Well, along comes a fellow named Norbert Wiener, and what he does is he documents the entire thing with a report, which he puts his name on, and then mimeographs it. Ditto machines. I don't know if you guys are familiar with ditto machines. This is before copy machines. And so then he takes 150 copies and has a workshop and tells everybody how to make a digital computer. A lot of people come internationally. And it was over a year later before the patent was applied for. Well, the court took until the 70s, after a company called Univac had been litigating against Sperry and the Sperry Rand Corporation, and they ruled that the publication of the mimeograph and its dissemination to an audience of 150 constituted a publication. That meant they couldn't have the patent, because a publication is a positive barrier to patentability. Famous court case back in the 70s. In fact, there was a whole book written about it, which I happened to read, and it was one of those things where, what a shame, because what they claimed was having invented, the general purpose digital computer. It was a compelling, a basic method patent. A lot of companies were violating it, including IBM, and as a result they could have gotten awards of triple damages, big awards, and the court just disallowed the whole thing. What a shame. So, how do I know if I'm the inventor?
Two things that make you an inventor. You have conception, so like aha moment, and reduction to practice. And if you have those two things, then you're an inventor.
But who gets the patent?
That's more up in the air. There's a million and one factors that could determine if you're the only inventor of what you're trying to patent or not. Because when you have your aha moment, there could be 5 people that are also having the same aha moment as you.
Well, actually, they could have had the aha moment after.
Even after, before, it could happen whenever.
You could have the aha moment 10 days later, 10 years later, I have the aha moment. But if I file first in this new America Invents Act first to file ruling, I get the patent. So it's really a question of who does their paperwork faster. Now, if you look at the Constitution, there's protection for the inventor, not the person who is the first to file. It's the first to invent. But we changed all of that about a year ago. That's when the America Invents Act went into effect, and this became a first-to-file country back in March of 2013. So as a result, a lot of people were in a rush to file before that change went into effect. And somebody at last night's meeting said they got in just under the wire with their provisional patent application because it was about to run out. So then comes the next question, well, what if I put it up on Kickstarter and offer it for sale? Well, in a compromise, the First to File Act says that if you're doing a publication, you can still wait an entire year before you do your filing. And the question then is, what about international patents? And the answer is, well, if you didn't file a provisional prior to publishing on Kickstarter, you are not eligible for an international patent. You lose that. And so that becomes a big problem for individuals who are interested in international patents. I can tell you they're terribly expensive. I think we may have spent over $100,000 on our international patent. But it's filed in Canada and Japan and the Paris Convention Treaty nations, and it gets translated into all the different languages, and there are many fees associated with the patent along the way. Milestone fees at different intervals depending upon which country you're in. And you have to hire legal firms in all the different countries. So it's quite expensive. And then the question becomes, what do you do about China? And I still haven't figured out the answer to that one, because I don't understand exactly how intellectual property works in China, if at all. They're not really very good with that. So we just skipped over China. And that's like 1 billion people. And maybe more now, I don't know. Hard to keep track. So this is a big question in my mind. And this is one of those things when I ask, I can't get an answer. An office action comes back and the patent examiner says, you can't have a patent because it's obvious. How do you know when it's obvious?
Obvious is a term of art. Means something very specific that's based on court cases that have been decided up until the point when you apply for your patent.
When a person who is a person skilled in the field determines that it's obvious, then it's said to be obvious. But the court could have several people skilled in the field say it's not obvious. Now in my case, they said an algorithm for doing stochastic Petri nets was obvious. And it had been published in a journal, and it was a peer-reviewed journal, and they still said it was obvious. And I was flabbergasted, and I was like, you guys must be brilliant. How did you know this was obvious? It took me a long time to figure it out.
Well, the way they would word it is, in light of one strong reference or two strong references, it would be obvious to combine those with this other reference, and the two of them together teach what it is that you're trying to claim your patent. So now the standard is very low. I think it's obvious to try. So it's like...
It's obvious to who?
Obvious to try, I think, is the most recent standard. everything, you could say, is obvious.
Everything's obvious.
Basically, they can make that argument because it seems like very simple. Let's say you're creating one new element you're adding to something that already exists.
Uh-huh.
All they have to do is find that new element in any patent and find a patent that teaches what you're already claiming, a strong patent, combine the two and say it would be obvious for Zeta, a person having ordinary skill in the art, to combine the two and make that rejection. And then it's on you. You have the burden of proving that no, it's not obvious. And if you can prove that to them, then you can overcome their rejection.
So this is a big question then. How do you prove something isn't obvious?
There's a couple different ways, depending on what it is you're trying to claim. So if your invention is a chemical invention, it's a little bit easier than like a software patent. Because if you're claiming a chemical invention, you can say that not only was it not obvious, but it had detrimental effects. So if you combine these two chemicals together, it always exploded. And now we found a way to do it where it doesn't explode. So not only was it not obvious, but people that had done this before had these detrimental effects. So it wasn't even obvious to try this because it always ended bad. And we now have a new way to make it that won't end bad.
I think that the way you say it is a long-held problem with commercial potential. And then you basically make the claim that it's not obvious. So a long-held problem which has been recognized and now solved, now you can prove it's not obvious.
Yeah, commercial success is also another factor that you can argue that if it was so obvious, why, like, is this such a successful thing that I'm selling now?
Yeah.
Like that.
So there are a couple of ways to go. I like the idea of the long-held problem. And then you could say, I have the long-held problem, now I have a solution. In hindsight, might have been obvious.
Yeah.
So I mean, here's an issue. Like, did Edison invent the light bulb? Right? I mean, you could say, well, all he did was pick the right material, and he used tungsten because it had a very high melting temperature, and anybody could have done that.
Well, there was another patent that was similar, but they had claimed too many different types of materials.
Oh.
So that's how he beat it.
Do you guys have to go at 6? There are some people who have other classes. No? Yes? So let's take a little break so that in case people have to leave, we'll stop the recording.